Good morning. From today we are going to start with the Indian Contract Act, that is Law of Contract 1872. Okay. Now first of all we will see that this act is having 238 sections. Okay. Now there are 238 sections, but previously there were 266 sections and 11 chapters. But now 2 chapters are been removed. And what we have done, we have removed the chapters, but for that we have passed different acts. Okay. Now section 76 to 123 is been repealed, and for that we are having an act, Sale of Goods Act 1930. Okay. And section 239 to 266 is been repealed, and for that we are having an act, Partnership Act 1932. Okay, I'll repeat. Indian Contract Act 1872 originally contained 266 sections and 11 chapters, but now 2 chapters are being cancelled. That is, the 7th chapter is being cancelled and 11th chapter is cancelled. Okay, the 7th chapter was relating to sale of goods. For that we are having a separate act now, and the 11th chapter relates with partnership, and for that also we are having a separate act, that is the Partnership Act 1932. Now the Indian Contract Act 1872 is being enacted by the Britishers, which came into force on 1st September 1872. The objective was to provide a uniform law relating to law of contract. Okay. Now the Law Commission, it was chaired by James Stephen. Now who is James Stephen? The person who has enacted the Indian Evidence Act also. Okay. Now he was the chairperson. His objective was that we should have uniform contract law in India. For that the act is being passed. Now it is having 238 sections. They are being divided in 2 parts. General principles of contract, they are in the first part, that is section 1 to section 75. Okay, section 1 to section 75 relate with general principles of contract, and section 124, I told you 7th chapter is been repealed. Okay, so section 124 to 266 is the second part that relates with special contract. We are going to see both the parts. Now the special contract, it means what? Certain types of contracts are there which are special, which are having some different elements. So they are in the second part, that is bailment, pledge, agency and all. Okay. So Contract Act has been divided into 2 parts. First part relates with general principle. The second part relates with special contract. First part is section 1 to 75 and the other part is section 124 to 266. Okay. Now the Britishers have enacted this law. Okay, but in India, in ancient time also, we were having the provisions of contract. Like the Hindu concept, they stated that promises are to be kept. You have to fulfill your promise. Otherwise, there will be bad consequences. And now what we say, we are having legal consequences. I'll sue you in the court if you make breach of contract. Okay, isn't it? So if it is a valid contract, you have to fulfill it. Now in ancient times also, they believe that when contract is entered into, it is being entered by mutual consent, that is by samanvay. Samanvay means what? Both the parties are having a mutual consent. That is, the contract is founded on this consent. It is an agreement. It is an understanding between the parties. The concept of offer or proposal, that was called as agraha, means a clear proposal is to be made by one party to the another. Now the other party is going to accept it. That was called as pratigraha. That is, the other person is going to accept in the same sense. It means the consent was free. There was to be a lawful object. There was competency to parties. In Manusmriti, it has been clearly mentioned that certain persons are to be excluded. Who are to be excluded? Lunatics, unsound mind, minors, the persons who are addicted to certain things, because they are not able to know for what they are saying yes or for what they are giving the consent. Therefore, free consent was essential. Fulfillment of obligation was very essential. Otherwise, they have to face consequences. At that time, there were social consequences, social condemnation, or they used to create a fear in the mind that you are going to face sin if you don't fulfill your promise. Okay. Now, in Hindus, this concept was there. Similarly, in Muslim law also, we are having the concept of agreement. Means a contract is based upon an agreement. It is an agreement between parties based on the principles of justice, fairness and transparency. Transparency means both the persons have to make a clear, one person has to make a clear offer, the other person has to make a clear acceptance. Nothing should be like undisclosed. Fraud should not be there. Misrepresentation should not be there. The concept of transparency is telling the same thing, isn't it? So in Muslim law also, free consent was essential. Object was to be legal. There must be a lawful subject matter. There must be an offer. There must be an acceptance. It must be from a competent party. And the contract should not be having some prohibited elements. So the concept which we are having today in the modern law in the sense what the Britishers have made, they were there in India in the ancient times and the medieval times also. Okay. Now you can say ancient law is influencing the modern law. Fairness is there, ethical elements are there, that is lawful object must be there. There must be a clear proposal, clear acceptance, and legal consequences are going to ensue if you don't fulfill the contract, isn't it? So ancient concept of contract is affecting, or you can say it is there in the Indian Contract Act 1872. So in general, we are going to start with the general principles first. Now what the general principles are telling, there must be a clear offer, there must be a clear acceptance, there must be consideration, there must be a lawful object, a lawful subject matter, and there must be a free consent, and there must be competency to parties. And whatever you are doing, whatever you are entering into an agreement, that should not be prohibited by law. It should not be declared as void. These are the main thing which are, you can say, these are the essentials of contract. Now our Indian Contract Act 1872 is based on English law. So as it was there in Hindus and Muslims, similarly in England also the law of contract developed in the same manner, that there must be a legal offer, there must be a legal acceptance, there must be consideration, and you can say the concept of vernaculum juris which they have created. What is vernaculum juris? Vernaculum juris is a bond between the two parties. In a contract there are two parties. Two parties are there. One gives an offer, the other gives an acceptance. And because of that, because of a contract, there is a vernaculum juris, a bond created. By that bond, both the parties are bound together, which we call it as privity to contract, isn't it? So through contract, what happens? Both the parties get certain rights, certain obligations, which they have to fulfill. If they don't fulfill, as it is a contract, the other party, the aggrieved party, will go to the court and ask for certain remedies. Compensation is one of the remedy, injunction, restitution, rescission, many remedies are there. But he is having full right to go to the court. But for that agreement should be enforceable in law. This is the definition of contract. Okay, we are going to see the clear definitions. We will go section wise also, and we will go concept wise also, so that you can get a clear picture of the act and also the concepts on which the law is based. Okay, I'll repeat. Two parties are essential, competent parties are essential, there must be a legal offer, a legal acceptance, a legal consideration, a legal object. The consent must be very much free, and those contract or those agreements should not be declared as void. Then only it is a contract. And if it is a legal contract, then there are certain formalities also which are mentioned in other laws. Those formalities are to be fulfilled, and if these legal formalities are fulfilled, a valid relationship between the two parties is created, and if one person makes a breach, the other person can sue him in the court and get the remedies. Okay, today we have just discussed the concept, or you can say the law, or you can say what we are going to see in the lectures hereafter. Okay, bye bye. See you in the next video.